everyone, and welcome back to the channel. This is the House of Law, and we have a guest today. His name is COVID-4. He is the fourth of four kittens born last March 28, 2020. Although they were born on the same day, but of course in the order of birth, okay, he's the fourth. Okay, now what makes this kitten cute is because he doesn't have a tail. All right. So, hi. Okay, send some love to this kitten and please like this video, and if you like, you can post some of your comments if you're a cat lover or pet lover. Okay, so first I'd like to thank everyone who watched my first video and subscribed to the channel. And within a few hours from the posting of that video, we already have suggested topics. First is becoming a lawyer, how to enter law school, and how to get admitted to the bar. And another topic suggested by a viewer was insurance. So how to take insurance and what are the basics of insurance law. And lastly, a former student of mine commented that he wanted to know what the property relations of people in relationships are. So keep those suggestions coming. Comment down below what you want us to talk about in the future videos. So as promised, our first video is about the attorney-client relationship. So after the video, please like it if you enjoyed it. Please subscribe to the channel if you haven't subscribed yet. And please click the notification bell for future videos. Thanks and enjoy! For a lot of people, they will never have the chance to meet a lawyer. And maybe that's a good thing. Lawyers are like doctors. We try to avoid them as much as possible. But unlike doctors who take care of us and treat us even if we're healthy, lawyers are resorted to when there are cases or when there are legal problems that need to be solved. Now, if that happens, one must be prepared, okay, to know the rights and obligations of the parties in an attorney-client relationship. When is an attorney-client relationship created? When is it also terminated? So, let's dive in. Are you an attorney? That is the first question. So, you are looking for a lawyer? A client usually commences or begins the relationship. It is the client who has a need for a lawyer. Now, a lawyer, of course, also needs clients, but the Code of Ethics prohibits a lawyer from soliciting or getting clients or cases, because that would be what we call ambulance chasing. So the relationship is created from the part or on the part of the client. So you found a lawyer, maybe through referrals or after checking the internet for listings. Now, the next question that you must answer is if this person is in fact a lawyer. Is he a member of the bar in good standing? A person is admitted to the bar by meeting the requirements provided by the Supreme Court. The Supreme Court is the institution or the government agency that prescribes the rules and regulations for admission to the bar. So first, a person must have completed legal education in a reputable school. He must have passed the bar, and he must have taken his oath. Now, a lawyer is in good standing if he is not suspended. Now, there is no easy way to find or to know if a lawyer is not suspended from the practice of law or even disbarred. So you have to check with the Office of the Bar Confidant with the Supreme Court to know if a lawyer is in fact in good standing. Now, of course, you have to also check who referred the lawyer to you. Okay? Because if that referrer is reliable, of course, he would not refer to you a bogus lawyer. Now, is he in the practice of law? You see, not all lawyers are in the practice of law, because the practice of law has been defined as a series of activities involving the application of legal knowledge. So what is the practice of law? In the case of Cayetano versus Monsod, the Supreme Court defined the practice of law as any activity in or out of court which requires the application of law, legal procedure, knowledge, training, and experience. So Sabi ng Supreme Court, hindi naman kailangan na uma-appear siya sa court. Hindi naman kailangan litigator siya. So, a lawyer who is employed as a corporate secretary in a corporation, as an in-house counsel in a government owned and controlled corporation, or even those engaged in or employed by the government as government lawyers are also in the practice of law. So they can dispense or give you legal advice. Now, the three principal types of professional activity, meaning the practice of law, particularly applicable to practicing lawyers, are, according to the case of Ulep versus the Legal Clinic, number one, legal advice and instructions to clients. So when a lawyer is sought for legal advice and that lawyer gives advice and suggestions as to courses of action, then he is engaged in the practice of law. Also, when a lawyer prepares for clients legal documents like contracts, deeds of absolute sale, then he is also engaged in the practice of law. And lastly, the traditional activity in the practice of law is the appearance for clients before public tribunals. Of course, this is not limited to courts. Kasama na rin po dyan ang appearance in the NLRC, HLURB, NBI, the Bureau of Immigration. Okay, so what kind of relationship is an attorney-client relationship? Is it a contractual one? Is it a natural or a quasi-contract? Is it a contract of lease of services? What is a contract of lease of services? In a contract of lease of services, a person hires or leases the services of another. Okay? There is no transfer of ownership because you don't actually buy the person, but you are paying for the services of another. So in an attorney-client relationship, does the client buy or hire the services of a lawyer? And if he does, what is the output? Okay? Is it the result of the case, or is it simply the services of the lawyer? Is it also a contract of agency? In a contract of agency, a person represents another in relation to a third person, okay, subject to the limitations of that authority. So, if you are familiar with lawyering, a lawyer usually says, respectfully appearing or respectfully representing Mr. Juan de la Cruz. Now, that is a contract of agency. But an attorney-client relationship is both and more. Okay? The lawyer enjoys independence and discretion. A lawyer cannot be dictated on matters of procedure. And in fact, a lawyer is given the wide range of independence even in the matters of substantive law. So ang abogado magsasabi sa iyo na may merito ang kaso mo o wala. And because of his specialized training, we give deference, okay, to that advice or to that recommendation of the lawyer. Now, also, the lawyer exercises discretion. Ibig sabihin ng discretion, he has the discernment. He can evaluate the case and he can make recommendations and suggestions. So that's why it's not just simply a list of services whereby a lesser of services will render the service required, and also it's not just a mere contract of agency where he represents another, but also a relationship of trust, a relationship of respect, a relationship of deference. A lawyer is supposed to know what he is doing. It is personal because the relationship exists based on the trust and confidence in one another. Ang abogado may tiwala dun sa kliyente. Okay, this client is a conscientious client. This client will obey his recommendations or suggestions. At the same time, the client relies on the lawyer's personal values, personal attributes. Now, the relationship is also fiduciary and confidential because in an attorney-client relationship, whatever is discussed, whatever is communicated between the client and the lawyer is strictly confidential and not discoverable. Ibig sabihin nun, kung may sinabi ang kliyente sa abogado, hindi pwedeng sabihin ng abogado sa ibang tao yun, kahit sa asawa niya. And that is what we call the attorney-client privilege or the privileged communication. The exceptions to privileged communication are number one, it is with the consent of the client. So the client can give his consent to the disclosure of his personal information and even personal communication and records. Also, when the privileged information is subject of a case and a court can order the disclosure of such information. Now, the relationship is subject to regulation. Ibig sabihin lang nito, the state has an interest in maintaining the sanctity of the attorney-client relationship and to make sure that the relationship does not impair the rights and obligations of the client as well as that of the attorney. Okay, so this regulation is done by the Supreme Court, okay, through the courts and through the Integrated Bar of the Philippines. So clearly, the relationship between an attorney and client is not an ordinary contract. It is not covered by the non-impairment clause of the Constitution. So when is a lawyer deemed hired? So you messaged him on Facebook, okay, which we which we get all the time, okay. And as lawyers are now reachable through Facebook, through Instagram, and other social media methods. Okay, you also talk to him in a supermarket parking lot, assuming that he is someone familiar, you know him, or he is referred to, and then accidentally you meet him at the supermarket parking lot, and then you discuss the case, or you have exchanged emails. Are these evidence of the creation or commencement of a lawyer or attorney-client relationship? You see, the relationship can be created in whatever form. It can be in writing, which is the very formal way of engaging a lawyer, or it can even be verbal. Now, the relationship is created even if the lawyer did not handle your case. Now, this is very important because the relationship, even if it was very brief, creates certain liabilities on the lawyer. Okay, all your documents that were transmitted or given to him, either personally or by email or by messaging, all these are confidential. Jurisprudence or ang tinatawag nating mga desisyon ng Supreme Court, they have established several indications of the creation of an attorney-client relationship. So first is seeking advice and assistance of an attorney and receiving it. Okay? Next is acting on behalf of a client in pursuance of a request from the latter. For example, meron kang tenant, tapos ayaw umalis ng tenant despite the termination of the contract of lease. So lumapit ka sa abogado, sabi mo sa kanya, pwede bang gawan mo ako ng demand letter para umalis na yung tenant ko? So there was no response. He did not say that, okay, I accept your case, nothing. But then, he prepared a letter for you, sent it to the tenant. Preparing a letter and sending it to the tenant pursuant to your request is an implied acceptance of the engagement. So, abogado mo na siya. Also, receiving from a client documents relative to a claim against another person and preparing the necessary pleading for institution of a suit for recovery thereof. When you submit or when you give a lawyer documents, which documents are needed to pursue a claim or to defend a cause, and if that lawyer files a pleading, ibig sabihin meron siyang final sa court, this can be a complaint or any initiatory pleading, or this can be an answer or a comment. These actions on the part of the lawyer signifies his acceptance of the engagement. Now, also writing letters on behalf of a client addressed to third persons regarding legal matters. For example, may problema ka sa SSS, may problema ka sa, or meron kang kailangan sa BIR or any other agency. When a lawyer writes letters for you and addressed to third persons, then that is also his acceptance of the engagement. And lastly, the acceptance by a lawyer of money from a prospective client. What are the liabilities under the attorney-client relationship? So first, it imposes upon the lawyer certain restrictions circumscribed by the ethics of the profession, such as what I've said earlier, the privilege and confidentiality of communication, and the rule against conflict of interests. What is conflict of interest? Okay, this happens when a lawyer who previously handled your case is engaged as a lawyer by your opponent, or when he accepts a case that is adverse to your interests. Hindi po pwede yun. You know, even in an attorney-client relationship, loyalty is key. Okay, also, the professional employment of an attorney confers upon him the general authority to represent and bind the client. Ibig sabihin, when a lawyer appears for a client, there is a presumption that he is so authorized. The third consequence is that unless the engagement is pro bono, the lawyer is entitled to compensation for his professional services. A client has to pay reasonable attorney's fees. Now, what is reasonable will depend on a lot of things. First, the stature of the lawyer. Second, the complexity of the case. And third, the services actually rendered and to be rendered. Now, that's why it's safe that a contract be agreed or entered into by the parties, because in that contract the parties can stipulate on attorney's fees, appearance fees, and other contingent fees. Okay, so these are the liabilities under an attorney-client relationship. So next is, how do you terminate the attorney-client relationship? Of course, we will suppose that the business has been, as much as possible, that the business has been completed. But if not, pwede pa rin tapusin ang attorney-client relationship. So, the first is revocation of authority by client, and this may be done at any time with or without cause. If the case is filed in court and a lawyer is recorded as the counsel or attorney of a client to the case, that client is required to submit to the court a withdrawal of appearance or a termination of representation of that lawyer. Meron tayong tinatawag na rule na notice to the lawyer is notice to the client. And if a client is represented by counsel or by a lawyer, then that lawyer usually is the only person to be notified by the court. So that's why it's important that the client notifies the court so that the record can be changed and the court will no longer send notices to that lawyer. Next is by resignation or withdrawal by the attorney. So a lawyer can also withdraw or can resign from his job as an attorney of a client, but this must be done only for a justified cause and with the written consent of the client. Now, if the client does not give his written consent or conformity, okay, to the resignation or to the withdrawal of appearance, the lawyer can move and can petition the court to allow him to resign or to relieve him from his functions or duties as a lawyer. So either of these can terminate the attorney-client relationship. A client can fire the lawyer, while the lawyer can resign as attorney for the client. But just because the relationship is over, it doesn't mean that they don't have residual or remaining obligations to one another. The attorney has to turn over all documents and monies that are in his possession to either the client or to his new lawyer. Also, the client must pay all unpaid attorney's fees, including contingent fees. Now, if either of them refuses, they also have remedies in law. A client can file disciplinary actions against the lawyer, while the lawyer can file a claim or a lien in whatever favorable judgment that the client can get from that case. So there you have it. We saw how the attorney-client relationship is created. We also saw the consequences of that relationship, including the liabilities of the lawyer to the client. And finally, we saw how this attorney-client relationship can be terminated. So I hope you learned something today. So the next time you find the need to get a lawyer, now you know. Thank you for watching.